Good evening, everyone. My name is Harshita. I'm a legal intern in LEXIS and Company. My topic is liabilities in torts. To know what are the liabilities in torts, first we should know what is torts. So, tort has derived from a Latin word tortum, which means to twist. So, torts means it is a breach of a duty, a legal duty, which amounts to a civil wrong. Civil wrong means a wrong towards another person and a damage is caused. Civil wrong means infringement of a person's right. Right here denotes legal right and not a moral right. The person who commits tort is called as wrongdoer or tortfeasor. Tort is a judge-made law. It means that it has come from various judgments given by the judges and now it has been combined and made a book known as torts. So wrongful act which are beyond contract and trust give rise to claim for compensation, and these compensation are unliquidated, means it is not defined. So as we have understood what is torts, we should know that there are three things which should be kept in mind while talking about a tort. Like a tort is conducted by an act, omission or mistake. An act which need to be done but was not done is omission. Mistake, doing lawful thing wrongfully. It is of three types: malfeasance, non-feasance and misfeasance. So malfeasance applies to commission of those unlawful acts which are actionable per se and does not require proof on any ulterior motive of intention. Example, trespass. Non-feasance, omission to perform some act when there is some obligation to perform it and the person owes some duty of care towards it. Misfeasance, improper performance of some lawful act. So, a legal wrongful act is one which affects one's legal right. The wrongful act must be one recognized by law, and the act must be in violation of a law to be a legal wrongful act. There should be an injury. An injury must be an injury in the eye of law. Damnum sine injuria, damage without injury. Here damage implies actual physical damage, whereas injury implies violation of a legal right. Merely damage and no injury causes no compensation. Injury sine damnia, injury without damage. A violation of a legal right, even in the absence of a damage or loss, to maintain a claim of violation of legal right need to be present, irrespective of actual or physical damage. So here we have now we'll talk about the liabilities. There are three types of liabilities: strict liability, absolute liability and vicious liability. Strict liability was originated from Rayland versus Fletcher case. Strict liability focuses on the nature of the defendant activity rather than as in negligence. Strict liability is where a person is held responsible for unforeseeable harm despite having taken all reasonable care to avoid foreseeable harm. The rule established in this case was if a person brings on his land and keeps any dangerous thing and that dangerous thing escapes from him and creates a mischief, he will be held liable for the damage caused by its escape even though he had not been negligent in keeping it. So here essentials are dangerous thing. So person should have some dangerous thing which should be in his property or in his land. Escape. Second is escape. To apply strict liability, the rule it is essential that the thing causing the damage must have escaped. Third is non-natural use of land. It must be some special use bringing with it increased danger to others and must not merely by ordinary use of land. What is absolute liability? It has originated from MC Mehta versus Union of India case. There is no exception in any liability when a person brings a danger on your land, when on his land, and when it escapes, it creates a liability. Vicarious liability is liability of a person for an act committed by another person, and such liability arises due to the nature of the relationship between them. This is master servant relationship, partners in a partnership firm, principal and agent. So